Good morning and welcome to the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Daly,
Here.
Senator Ellison, Senator Flores, Senator Lang, Senator Rogish, Senator Scheibel, Senator Steinbeck, Chair Pizzino.
Present. Please mark Senator Lang absent excused, and please mark Senator Flores present when he arrives. Welcome to the members of the audience in Carson City, Las Vegas, if anyone is in Las Vegas, and those following our meeting online. Before we begin, I'd like to make several housekeeping announcements. First, I'd like to remind everyone to please silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which are listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of. If you wish to testify in person, please sign in at the table by the door and leave a business card with our committee secretary. When testifying in person, please turn the microphone on to speak and off to listen, as we have others listening and viewing in the meeting in Las Vegas as well as online. And please also state and spell your name for the record. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Committee members will be using their laptops to view handouts and other exhibits. Please do not view this as a sign of disrespect or inattention. With that, we are going to move on to our very first agenda item of the day, which will open the hearing on Senate Bill 49, revising the provisions relating to consumer protection. Please come on up to the table when you're ready, and thank you.
Such a bouncy chair. Good morning, Chair Pizzino and members of the committee. It is great to see you all. My name is Aaron Ford, and I am your Attorney General. I am accompanied today with several members of my staff. To my right is my Chief of my Consumer Protection Bureau, Mark Kruger. You will hear from him shortly as he presents Senate Bill 49. In the audience is also my Chief of Staff, Teresa Benitez Thompson, as well as my colleague, Mike Morton, who, among other things, works with me on my legislative agenda. And we also have a member of the Consumer Protection team, Michelle Ballerini, in the audience as well. Rest assured, no one else but the two of us are testifying. I just wanted to introduce them all to you and let you know that they were here. So as I've indicated, Mr. Kruger is a Chief Deputy Attorney General in my Consumer Protection Bureau. He does yeoman's work in protecting Nevada consumers from bad actors through the private sector. Senate Bill 49 is an effort to enhance our ability to do exactly that. Consumer protection is one of the most important spheres in which my office works. It is an expansive field and one that requires constant monitoring and attention due to the shifting issues facing consumers today. For example, my office has become hyper-vigilant in the issues of consumer scams, a scam tactic that has continued to increase in both frequency and sophistication. Due to the very nature of these crimes and these acts, they can be difficult to prosecute and even litigate, as scammers are excellent at disappearing once their scams have been completed. As such, my office has made it a point to work diligently to educate the public about trends we see from scammers. In fact, the BCP, Bureau of Consumer Protection, conducted over 177 different types of outreach and education, including in-person events, social media content, and public service announcements over the 2022-2024 biennium. Again, that's over 177 different types of outreach. It's important to note because my office operates under a motto, and that motto is, our job is justice. And part of the ways in which we accomplish justice is through our what we call 5 C's. One of those C's is consumer protection. We're talking about that today. But another C is community outreach. The 177 different types of outreach is quite indicative of the way in which we try to effect justice in our community. Cutting these crimes off before they happen through consumer education is one of our most powerful tactics in fighting increasing scams. The Consumer Protection Bureau has done phenomenal work as well in one massive area in which Nevada consumers were terribly victimized. Our office has brought in a combined $1.2 billion, with a B, dollars from companies responsible for the opioid epidemic that has had an outsized impact on our state and its residents. earmarked for programs meant to mitigate the effects of the epidemic. The BCP also handles other enforcement actions against companies that have sought to harm Nevada and its residents. For example, protecting children from harmful effects of tobacco vaping products in the form of a settlement with Juul Labs in the amount of over $14 million. Another example is protecting consumers, consumer location tracking through a settlement with Google in the amount exceeding $6 million. We've also protected Nevadans from the harmful effects of talc through a settlement with Johnson & Johnson, also exceeding an amount of $6 million. We've also protected consumers at the point of sale through a settlement with Walmart that arose actually out of a complaint very near here in Reno, in Washoe County. We received a complaint that at the shelves, the price for products was different at the register. They were charging more at the register. And so Walmart and my office engaged in communication, and we obtained a $2 million settlement directly affecting members of our state relative to interactions that Chain Store was having with our constituents. In total, it's important to note that since I have taken office, the BCP has obtained more than $185 million in settlements and judgments, all toward affecting consumer protection. These are just a few of the areas in which the very capable staff in my office works tirelessly for Nevadans. The bill that Mr. Kruger will present today is meant to give these public servants further tools to protect Nevadans and to make their job responsibilities smoother. SB 49 is intended to help our state employees do what they do best, and that's to help Nevadans. I'll now hand it over, Madam Chair, if it's okay, to Mark Kruger to discuss the bill's provisions.
Good morning, Mark Kruger for the record, Chief Deputy Attorney General in the Nevada Attorney General's Office. Madam Chair, members of the committee, thank you for having us here today. Senate Bill 49, as General Ford said, is basically, in all short term, a consumer protection cleanup bill. It gives us the ability to make changes to Nevada Revised Statutes, Chapter 598, which is the Deceptive Trade Practices Act, Chapter 598A, which is the Unfair Trade Practices Act, and just a small provision under the Consumer's Advocate provision of NRS Chapter 228, which is the Attorney General's provision where the Consumer's Advocate Authority resides. Quickly going through the bill, by way of background, in 2021, Chapter 598, the Deceptive Trade Practices Act, was amended to allow the Bureau of Consumer Protection to conduct certain administrative actions. These administrative actions were in addition to the district court actions that we already have authority to do, just another tool to help assist consumers out there. Sections 1 through 8 of the bill outlines how the Bureau of Consumer Protection would have the ability to handle those administrative hearings the same way that other agencies do, particularly agencies in the Bureau Business and Industry, thank you. And like, for example, Division of Insurance handles them. Of note, in Section 4, Nevada Consumer Affairs discussed with us a friendly amendment. Nevada Consumer Affairs Unit under the Business and Industry is a co-enforcer of the provisions of the Deceptive Trade Practices Act. We have no objection to their friendly amendment. I think you find that a copy has been given to each of you. All it does is restore under Section 4, paragraph 7A, 7B, and 7C, and paragraphs 8 and paragraph 9, just puts them back in. We have no objections, as I said. Section 8 clarifies the definition of the term profits, and Section 9 and through 10, by way of background, also in 2021, the statute of limitations was amended for the Deceptive Trade Practices Act, removing it, and we're requesting to do the same here for the Unfair Trade Practices Act. Both of these statutes are the two statutes that we primarily enforce for protecting consumers. Section 11, also by way of background, in 2021, Chapter 228 was amended to address the use of recoveries. And what we have found is that the Government Finance Office and our Attorney General's Office fiscal unit have requested additional changes just to ensure that the money is put into the correct budgets and the budgets are funding the correct people. So a simple amendment there, as I said, a cleanup provision. Section 12, finally, also again in 2021, Chapter 228 was amended to allow the recovery of documents from other agencies, boards, or commissions. We have found in our litigations that there is a need to make sure that we actually aren't assumed to have those documents until we actually request and receive them. And so that change is very, very simple cleanup. That is my testimony. I'm happy to take any questions, and thank you all for your time.
Members, do we have any questions? Senator Rogich.
Good morning, and thank you, Attorney General Ford. It's an honor to have you here today. With regard to this bill, will it also address deceptive trade practices in the illicit cannabis and intoxicating hemp markets, which would ensure compliance with consumer protection laws and public safety?
Mark Kruger, for the record, through you, Chair, to Senator. We are already working with the Cannabis Compliance Board to address exactly that. This bill would actually provide additional tools for us to do that on an administrative level. We have the ability to do it now, but it would streamline the process. So yes.
Thank you so much. And you can go directly to the senator who asked the questions. Thank you. Senator Daley.
Thank you, Madam Chair. A couple of questions, mainly for clarification, I hope, because from what it sounds like from the amendment, you're adding back in, and you mentioned co-jurisdiction. So I was just curious how that worked, because when I read through the bill, so you have the Commission of Consumer Affairs, the Attorney General, the Director of Business and Industry, and then the Consumer Advocate within your office, all apparently seem to have some type of jurisdiction. And then in subsection 2, it says the commissioner or the attorney general can bring an action, and any hearing must be conducted before the director or the consumer advocate. So my question is, how is jurisdiction determined on which one of those is going to have the hearing? Are the hearing procedures the same? Do you guys default to 622, or is there different rules? And if I'm in this one, I have to, different dates, I have to turn things in, and if the other, and how are you determining, is it whoever files the case first? How you determine who goes to who? And if you guys have that all worked out already, or the amendment clarifies some of that, I just need to hear so I understand, so that people, like you say, that you're trying to protect, if they're getting accused, they have rights too, and we need to make sure we have a fair process.
Mark Kruger, for the record. Thank you, Senator. That was a great question. Yes, we currently do handle administrative actions now. Under Chapter 228, the consumer's advocate has the authority to exercise the authority of the Attorney General in consumer protection. So yes, you're correct in that the consumer's advocate and the Attorney General have independent authority, as well as the Nevada Consumer Affairs Unit. However, we represent the Nevada Consumer Affairs Unit in administrative actions. The Consumer Affairs Unit has adopted regulations that outline the rights and procedures of each of the hearings. Also, Chapter 233B also controls. So the protections, due process protections, and procedural protections are in place currently. You are correct in that whoever files the action, so if it was Consumer Affairs Unit, we were representing them on, by and through the Attorney General's office, that would be a Consumer Affairs action. If it was the Attorney General's office on our own, as we currently do, that would be a Attorney General's office action through the Consumer's Advocate or on the Consumer's Advocate's own behalf. I hope that answers your question.
Thank you. Yes, I believe it does. If you have consistent hearing rules or stuff, we're not trying to look to protect bad actors or any of that kind of stuff. But you don't want a smart lawyer, and no offense to any of my lawyer friends, right? You have a smart lawyer, if they don't have a fair adjudication of the case, it puts the whole prosecution at risk. second question, just clarifying, and so the way I read it in section 4, subsection 3 on the penalties, so the new minimum penalty, the way I read that, is going to be 15,000 basically. It could be higher based on the treble damages, but the new minimum is 15.
Thank you for the question, Senator. Mark Kruger for the record. Yes, what that penalty does is put it in line with the other statutory penalties that were increased back in 2021, which is the 15,000. So it would put the administrative penalties the same as the district court penalties, which makes it congruent. The interesting thing to note is that the changes for the penalties against minors or penalties against older adults, was already, because of the way the statute was written, increased when those penalties were increased. So penalties against the older adults, for example, are already 25,000. So bringing the standard penalty up to 15,000 makes sense in our thought process.
And thank you. I just wanted to
Yeah.
get that explanation because it's a big jump, but it's justified based on all of the other provisions for similar issues. Final question, if I can, Madam Chair. So in section 12, and I don't have any problem with you guys being able to get information from whoever you're going after, including otherwise confidential information. I just think it needs to be made clear, maybe you need an amendment, or that you probably already have the provisions, that if you do get that confidential information, then it doesn't then become public and is able to be requested through an information request. So you have to maintain that confidentiality. I believe that needs to be made clear, put in statute, however, and that you would only then release it in the usual ways is if the person whose information says yes, or you need it for your prosecution, or the court orders you to release it. I think those are the normal courses, and I think getting access to that you need to have. But I think you have to maintain the confidentiality if it was already confidential. Otherwise, you put it into a new area and someone can just request it and break the confidentiality. And I just think that needs to be made clear, hoping you can work on an amendment or something.
Mark Kruger for the record. Senator Daly, thank you for the question. I believe that already is addressed. When we made that change, that was an important piece of maintaining an investigation as confidential. If you look to NRS 5980964, that's our confidentiality of investigation, so it would maintain the confidentiality of that information until the clauses are triggered underneath that provision. So, but certainly happy to look at it. If you think if we need to do some additional clarification, we certainly can look at that.
Well, and I understand that it would be confidential for the period while it's under investigation. You wouldn't release it unless you need it for prosecution or the court ordered you. But then after that's done, it's in a file, the case is closed. I think that's the time frame that we would be looking at, because now it would be subject to, after the investigation, the case is over.
Mark Kruger for the record, we'll certainly look into that amendment. That's fairly simple, I think.
All right. Do we have any other questions? Senator Flores.
Thank you, Madam Chair, and thank you both for the presentation. I just wanted to get a point of clarification through the line of questioning of Senator Daly. The jump from 1,000 to 15,000, that's per violation. And then there's an additional, if I understand it correctly, under Section 4, it would go from 1,000 to 15,000 per violation. And then Section 6 triggers an additional penalty that you can cap on top of that if it's an elderly person or a minor of $25,000 more dollars. Is that correct?
Mark Kruger for the record. Thank you, Senator Flores. Not quite. The $15,000 is for general violations of the Deceptive Trade Practices Act. There already exist penalties of up to $25,000 if those violations were against elder persons or minors. So it's an either or.
Understood. And thank you for that. And would you mind, and I know that it would just make it easier for us, would you mind just very quickly walking us through a step-by-step hypothetical? Here's an individual that's suspected of committing XYZ. Here's the administrative hearing that they get. If they don't show up to that, you have the intervener process that triggers. But could you just walk us through that just so that we all kind of have a general idea of exactly how that would work? And it also would give comfort for the questions regarding due process.
Mark Kruger for the record. Thank you, Senator, for the question. Sure, I'll be happy to do that. So let's say a business or individual, in this particular case, we'll talk about business, is selling goods or services, hypothetically mattresses, and they're selling mattresses, but when the consumer goes in to purchase the mattress, they pay for the mattress, and then the allegations are that the business does not deliver the mattress. So there would be a deception, misrepresentation that you actually get something when you're not given it, even though you paid for it. So we would investigate, determine whether or not there's evidence to support the allegations. Finding that there was evidence to support those allegations, we would file a formal charging document, which is called an order to show cause. The order to show cause would be served through due process procedures that are already in the law on the business or individual or both, and then that person would have a time frame in which to appear for a hearing. They also would be notified of their right to have counsel, right to produce their own subpoenas, right to gather their own evidence in support of their defense. We would appear at the hearing, which would be set out at an appropriate time to give all the individuals time to be able to gather their evidence together and prepare for the hearing. We would appear at the hearing, and if the burden is on us to present the evidence and prove to the hearing officer that we would actually have shown that the evidence supports the allegations that, in our example, the mattress wasn't delivered after somebody paid a certain sum of money for the mattress. Following that, the hearing officer would enter an order, presumably in favor of us, and find that there was a violation of the Deceptive Trade Practices Act. After the order was issued, the individual would have a right to appeal that pursuant to provisions already in the law. It could be appealed to the district court. After that, they could appeal to on up the chain all the way to the Nevada Supreme Court if necessary.
Perfect. Thank you for that.
If I may just real quickly say, you can quite understand, I think, why I'm so proud of my BCP. Mark Kruger and his colleague, Ernest Figueroa, who is the consumer advocate, consummate professionals, know the statutes inside and out, understand the 5 C's, including consumer protection, but also the protection of constitutional rights. When you talk about due process, many people think we're talking about the criminal context. In the administrative context, there are constitutional rights that my office ensures that we protect, and what you've just heard outlined by Mr. Kruger is a great example of ensuring that our 5 C's are incorporated in our effect of justice throughout the state. So thank you so much, Mark, for that explanation. I just kind of want to chime in and give him kudos where they were due.
Thank you so much. And I believe Senator Steinbeck has a question.
Yes, thank you, Madam Chair. Thank you both for being here today and for your testimony. I wanted to know at what point or how do you ensure that the consumer gets some of that money back or gets some of the damages back in those instances?
Mark Kruger for the record. Thank you, Senator. That's a great question. Within the Deceptive Trade Practices Act, we have several tools. One of those tools includes restitution. Restitution is one of the first and foremost things we look to getting in order to return, make the victims whole whenever there's a violation of the Deceptive Trade Practices Act. We also have disgorgement. We have the actual fines and penalties. So there are several different things, but restitution being one of the most important.
And Aaron Ford, for the record, just as an example, my office undertook an investigation against some private colleges and universities that had taken money from Nevadans. And we recovered those monies and were able to get those distributed back to Nevadans who had been scammed under those circumstances. Again, a prime example of the 5 C's at work under the auspice of seeking justice for our constituents and our constituents receiving recompense for those violations.
Okay, thank you. I could just see how difficult it would be, like, for instance, the Walmart settlement that the Attorney General spoke of. How would you find the people that were harmed in that and make that restitution?
Thank you, Senator Mark Kruger, for the record again. That's a great example, if I might, Chair, just address that quickly. One of the things we also look for in any of these settlements is injunctive relief terms. And in that particular instance, the state of Nevada is one of the first that's going to get digital shelving so that it stops this problem from happening in the future. We worked with Walmart in crafting that settlement, so there was some fines that came in to address the wrongs, but there was also the injunctive relief terms, which are always so important in these settlements. Opioids is another example. Sure, we did get a lot of recoveries for the people who have been harmed through services and programs operated by the state, but we also got injunctive relief terms so we can identify practices that were causing the epidemic in the first place.
Thank you so much. I believe we have one more question from Senator Ellison.
Thank you, Madam Chair. I really enjoyed how you brought up the questions about the mattresses. One of the questions I've got, if they had a mattress and they didn't deliver it, so the cost of that delivery would be probably $100 or so on. So how would you adjust the fine? Because you can go up to $15,000 according to this. Is that correct?
Mark Kruger, for the record, that's correct for the fees and fines portion. But if we were looking for restitution, we would look for the out-of-pocket expenses by the consumer.
Okay, and then the cost of court and the attorneys and that kind of stuff. So what would something like that end up being to the small business that did charge them for delivery or whatever? I mean, how would you calculate that? Because you wouldn't charge them $15,000 at a flat fee, I don't think, would you? You would say, this is what it's going to cost. This is what our cost was for the state. This is what it cost the consumer had to pay. Can you explain that?
Mark Kruger, for the record. Yeah, generally speaking, when we're doing an example of the mattress, if it's a single mattress that is not delivered and the consumer has a right to it, we're generally looking for restitution for the purchase of that mattress and in lieu of any fees or fines. The fees or fines are there in the event that someone doesn't want to cooperate, doesn't want to end up giving out the restitution. The other tool that we use the fees and fines for is in patterns of practice. So if it's a consistent pattern, so you have a general, this company's been doing it for quite some time and hasn't delivered 100 mattresses, and there are 100 consumers out, they may need to have some fees or fines on top of the restitution or in lieu of the restitution if they end up not wanting to pay.
I thank you, and that explains that a lot. Thank you.
Thank you.
All right. Any other questions from members? With that, thank you very much for the very in-depth presentation and all the answers to the committee. We'll have you step back from the table and we will open up testimony in support of Senate Bill 49. Please come up to the table in Carson City or Las Vegas in our physical locations, and then we'll go to the phones afterwards.
Chair, members of the committee, Jonathan Norman, NORMAN with the Nevada Coalition of Legal Service Providers. I want to thank the Attorney General for always protecting consumers and standing in there when people are subject to scams. I appreciate this bill because it gives them a tool to continue that protection of, just everyday folks who go to buy a mattress and it's not delivered, or go to Walmart and get charged more than they should. So I urge your support. Thank you so much.
Thank you. I think we'll all think about mattresses a different way after this hearing. Anyone else in Carson City, Las Vegas? Broadcast, is there anyone on the phones in support of Senate Bill 49?
If you would like to testify in support of SB 49, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to participate at this time.
All right. Thank you so much. With that, we will close support on Senate Bill 49 and open it up to opposition of Senate Bill 49 in Las Vegas as well as in Carson City. Please come on up to the tables.
Good morning, Madam Chair, members of the Senate Committee on Commerce and Labor. My name is Brian Wachter. I serve as the Senior Vice President at the Retail Association of Nevada. We appreciate the opportunity to speak here today, and we fully support robust consumer protections, but we feel that SB 49 raises serious concerns that could affect Nevada's business climate adversely. We heard from the Attorney General just recently how effective their office has been at returning millions of dollars in these particular instances to the state. You heard about how a Walmart had difficulty changing a tag during a weekly process before it got to the checkout stand. And what I'll remind you is you've all been in a Walmart, and there are a billion different products. Those prices change, especially on weekly advertisements, and so it's literally humans' jobs to go through and change the tags, and sometimes they don't do that correctly. But what we have is an Attorney General's office who has the tools to be able to respond to that, to be able to provide those relief, and to be able to get the injunctive relief that the state sought. So SB 49, we're not sure, actually enhances the Attorney General's ability to go after more. We didn't really hear that there were actions that the Attorney General or any of the divisions could have taken, that they were hamstrung or handcuffed, and so we're unsure why this there's a nexus or a genesis to this particular bill. We do have due process concerns, mainly because, as you've heard, it's a complicated and convoluted regulatory process. We do feel the 1,400% increase in the fines from 1,000 to 15 are excessive. The Attorney General is empowered to provide higher fines in areas that the legislature has deemed to be of utmost importance, but on a normal course of business, it sounds like the Attorney General has all the tools that he needs to be able to do that. We do think that the bill's severe penalties, which include those $15,000 fines per violation or the tripling of the restitution, impose a heavy financial burden, and those steep penalties are likely to translate into higher costs for consumers, fewer job opportunities, and diminished resources for continued investment in Nevada. We appreciate your time. We look forward to being able to work with the Attorney General's office to see if there's a path forward, and we look forward to reporting back on how that goes. Thank you, ma'am.
Good morning, Madam Chair, members of the committee. Paul Moratin with the Vegas Chamber. The Chamber does have concerns regarding SB 49, but of course we recognize and understand the premise of the bill and what it is trying to achieve, and of course we have no objections to that. We have had brief conversations with the AG's office in the last week or two. We do believe additional conversations would be beneficial to further discuss, and of course we'll review the proposed amendment. But I would like to share with the committee some of the feedback we have received regarding SB 49. It has been mentioned regarding the fees and the fine structure and the treble damages. And also regarding in Section 8, the use of gross revenue is also a concern that's emerged from our partners and members. But like I said, though, we'll continue our conversation with AG's office. Thank you, Madam Chair.
Good morning, Madam Chair. Good to see you, members of the committee. For the record, I am Trey Abney, T-R-A-Y-A-B-N-E-Y, and here today as the State Director for NFIB, excuse me, representing small businesses throughout the state. I will associate myself with the comments made by the previous testifiers. Certainly, stories like Walmart and maybe huge mattress conglomerates and other large businesses that have millions and millions of dollars, is different than what most of my members see. And so we're concerned, our main concern, frankly, is the elimination of the statute of limitations. It's one thing if that mattress incident happened a month ago. It's another thing if it happened 5 years ago. And does a small business have the records and receipts and emails and letters still years later? And that's our main concern. Certainly, a huge increase in fines is also a concern. Yes, please go after the bad actors. But I'll be honest, every 2 years in this building, there are about 700 to 800 new bills that come through here and are eventually signed into law. Sometimes small businesses struggle to keep up with all the new rules and regulations that are flying through here. We would hope that business would be a helping hand instead of a punisher. The government could offer that. So anyway, the AG is well known in this building for putting together working groups and working through this. I'm sure it'll be no different. Thank you for your time, Madam Chair.
Thank you. And Mr. Wachter, I believe that Senator Flores had a question for you, if you don't mind coming back up to the table. Thank you.
And thank you again for the feedback. I was curious to know if any of your members, and maybe not yours, but maybe the chamber may be able to jump in on it. Do you have any examples of where any of your membership indicated that there was a one-time isolated incident where a small business made a mistake, using the hypothetical of the mattress, they didn't deliver the mattress one time, and that this was weaponized and really used to go against them aggressively with that $1,000 fine. I was just curious to know if you had an example of that, or if it's more anecdotal where you're just concerned, because obviously 1,000, 15,000 is obviously a significant leap, but I was just curious to know if you had any examples of that, please.
Brian Wachter, Senior Vice President of the Retail Association of Nevada, to you and through you, Madam Chair, to Senator Flores. I are less concerned about the individual instances. We have not actually come across members who have suggested that the current process isn't working appropriately or have felt that they were harmed. What we are concerned about, right, is the fact that we are looking at such of a broad statute in order to be able to go after some bad actors. You are necessarily, and I think to Mr. Abney's point, increasing the cost of doing business for all businesses. The fact that there is an indefinite period in which an action can be brought against you is necessarily means that your legal fees are going to increase, the cost of doing business is going to go up, and those prices are going to have to be reflected in that. And so because we are looking at that is where it is just a general concern for all of our members and not specifically the members that have interacted with the Attorney General's office.
Thank you. Appreciate that, Madam Chair. Thank you.
Thank you so much. I believe Senator Scheibel, did you have a question for legal?
Yes, and thank you for taking my question out of order. It was just something that someone said in opposition that prompted my question. I don't see in the bill where the statute of limitations is changed.
Thank you, Chair. Excuse me, Jeff Coulomé from LCB Legal Division. I believe, Senator, that's in sections 9 and 10. But I'd be happy to look into that more specifically, confirm that, and provide that information back to the committee.
Thank you so much, Mr. Coulomé, and thank you, Senator Scheibel. We are going to move to Las Vegas for testimony in opposition of Senate Bill 49.
Thank you, Chair Pazina and members of the committee. My name is Emily Osterberg, Osterberg, and I'm here representing the Henderson Chamber of Commerce and our over 2,000 members, the majority of whom are small businesses, to express our opposition to SB 49. HEC supports protecting consumers. However, we are concerned that SB 49 will have a negative impact on the Nevada business community. First, the bill includes a substantial increase in fines from $1,000 to $15,000. In addition, the removal of the statute of limitations does create an increased liability risk for the business community. Furthermore, HEC is an advocate of requiring that the party at fault pay damages based on actual profits rather than focusing solely on gross revenues. We fear these increased financial burdens will specifically impact small businesses. Thank you.
Cara Brown, Administrative Law Judge, Department of Business and Industry. Madam Chair and committee members, good morning. I'm here today on behalf of the Department of Business and Industry Consumer Affairs Unit. As you may know, the Consumer Affairs Unit investigates deceptive trade practice complaints and, as earlier noted, is a co-enforcer of the deceptive trade practices laws. The Consumer Affairs Unit uses their best efforts to get full restitution and other remedies for Nevadans who are the victims of deceptive trade practices. The unit handles well over 1,800 cases a year, mostly representing individuals, such as in the mattress case example given by the AG's office. The AG's office, on the other hand, typically handles the pattern and practice cases that are brought that involve potential deceptive trade practices. For that reason, the Consumer Affairs Unit is keenly interested in SB 49, which, among other things, proposes significant changes to NRS 598. We commend the bill sponsors for working with me over the weekend to come up with the friendly amendment which addresses our concerns with Section 4, Paragraph 7 of the bill. However, I want to put on the record that we have had discussions with the Attorney General's office regarding our concerns with Section 4, Paragraph 2 of the bill. Section 4, Paragraph 2, much as Senator Daley noted, proposes to duplicate responsibility for hearing deceptive trade practices cases. Under existing law, the director of B&I or his designee is given the responsibility of conducting deceptive trade practices administrative hearings. SB 49, Section 4, Paragraph 2 proposes to add a provision that also allows the consumer advocate in the Attorney General's office to conduct deceptive trade practices hearings. If this committee believes that the duplicate responsibility is appropriate and necessary, we'd like to see language added to SB 49, Section 4, Paragraph 2 that clarifies which cases are to be heard by the director of B&I or his designee, and those that are to be heard by the consumer advocate in his or her designee. We'd also like to see details around whether the procedures would be the same, again, much as Senator Daley mentioned. We stand ready to work with the AG's office and this committee on any clarifying language. Thank you. I have no further comments.
Okay. Broadcast, do we have anyone on the phones in opposition of Senate Bill 49?
If you would like to testify in opposition of SB 49, please press star 9 now to take your place in the queue.
Good morning, Madam Chair and members of the committee. For the record, this is Andy McKay. I'm the Executive Director of the Nevada Franchised Auto Dealers Association. My last name is spelled M-A-C-K-A-Y. We are opposed to the bill as drafted. However, it's important to note that the association and our respective dealer members strongly believe in consumer protection. With respect to the bill itself, our opposition lies primarily found in Sections 4 and Sections 9 and 10. Specifically, as previously mentioned in Section 4, subsection 3D, which increases the fine 15-fold from $1,000 to $15,000 per violation, as well as the elimination of the statute of limitations that is found in Section 9 and 10. I would like to echo Mr. Abney's comments that AG Ford and his team have a stellar record of forming working groups and working with interested parties in measures in which they have an interest in, and as a result, if that opportunity avails itself, we would love to participate in. So, Madam Chair, thank you for your time.
All right. Thank you so much. Broadcast, anyone else on the phones?
Chair, you have no more callers at this time.
Thank you very much. We will now close testimony in opposition of Senate Bill 49 and open up testimony in neutral of Senate Bill 49. Is there anyone in Carson City or Las Vegas? Seeing no one. Broadcast, is there anyone on the phones?
Chair, you have no callers at this time.
All right. Well, I would invite the Attorney General's team to come back to the table and make any closing comments.
Thank you very much, Madam Chair. Aaron Ford for the record. I forgot to spell it the first time, A-A-R-O-N, last name F-O-R-D. Thank you so much for the opportunity to come in and respond briefly to some of the testimony received after our case in chief. We did hear from Mrs. McKay Abney, and at some point over the last couple of weeks, we heard from the Metro Chamber, and we appreciate them coming to us and letting us know they had concerns at the outset so that we can continue to work together. Those who came up today and mentioned for the first time what their concerns were, we welcome them to reach out to our office. As Mr. McKay and Mr. Abney have indicated, we have always had an open door policy to receive information, suggestions, amendments, and whatnot. And by the way, I should have mentioned BNI. Thank you so much for working with us over the weekend to ensure that we could bring this amendment back to the committee for consideration as well. What I will say, and then I'm going to give it to Mr. Kruger for his continued amplification of this issue, is that, as a reminder, the penalties that we're talking about from 1 to 15,000 are to make them congruent with other parts of the law. Meaning that they were left behind and they need to be brought to parity with other components of our Deceptive Trade Practices Act law. And also the new tool that we're talking about, some have indicated that they don't view this as a new tool. A couple years ago, we addressed the Deceptive Trade Practices component. This addresses the unfair trade practices component. Two different types of causes of action that address two different types of actions that we're trying to address. And so with that, I'm going to turn the mic to Mr. Kruger so that he can continue to amplify on this particular issue. Thank you so much.
Thank you, Mark Kruger, for the record. General Ford's exactly right. When we talk about the statute of limitation, it's really a need, there's apparently a need for some clarification. The Deceptive Trade Practices Act, which is NRS 598, the statute of limitations was moved out of it in 2021. So there is no statute of limitations currently in the law for violation of the Deceptive Trade Practices Act. Think again of our example of selling a mattress, a good or service, a misrepresentation, deception. That kind of act already doesn't have a statute of limitation. This will remove the statute of limitations for the Unfair Trade Practices Act. Think antitrust, which is codified in Chapter 598A of the Nevada Revised Statutes. So when we go to Mr. McKay and his example of a car dealer, generally speaking, the deceptive trade would be a deception in the sale of the car, where the unfair trade practices would be collusion between car dealers, say in the greater Las Vegas market. We're all going to get together and conspire and collude to set prices for minimum price for a certain car, for example. So two very different acts and two very different statutes. So the Deceptive Trade Practice statute of limitation, again, has already been removed. This would just bring that into parity. Also, to address some of the comments about how small businesses may be infected, and I particularly heard a notation that the amount of cost might go up because a penalty might go up. I respectfully disagree, and here's why. The administrative action is, generally speaking, a less expensive tool than filing a district court action and having the matter go through the district court proceeding. Remember, currently in the Deceptive Trade Practice Law, the Attorney General's office already has authority, no matter what size the business is, to file a district court action to enforce the violations, which are already set at $15,000. We're simply trying to, and we have the tool for the Administrative Act, we're trying to basically streamline the process, make it more efficient for us to bring an action for an administrative action where the fine would be $15,000 in parity with the district court action, which actually in a lot of ways might reduce the amount of legal cost that a business would have if, on the other hand, we would bring a district court action. So I hope that helps provide some clarification to the two main arguments that I heard. Also, we are, as General Ford said, always willing to work with any one of the opponents to see if we can get them to make some small changes that doesn't change the intent of the law, but maybe accommodate some of the concerns that we heard today. Thank you.
Thank you so much again for your presentation and for your willingness to work with stakeholders across the board. And I hope that everyone comes to the Attorney General's office and continues to have conversations. So thank you so much. And with that, we will close the bill hearing on Senate Bill 49. And that will move us to the next item on the agenda, which is public comment. Members of the public may provide public comment in person, by phone, or submit written public comment to the committee's email. Instructions for providing public comment may be found on the agenda, including the call-in information. We look forward to hearing your comments and ask that you keep them brief and please avoid repetition made by previous speakers. Finally, clearly state and spell your name for the record. We'll begin with public comment from those in our physical locations and then move to anyone who's called in. Do we have anyone in Carson City who'd like to make public comment? Seeing everyone heading to the doors and not the table, we'll move to Las Vegas and see if anyone has any public comment in Las Vegas. It looks to be similar there. Broadcast, do we have anyone on the phones who'd like to make public comment?
Chair, your public line is open and working, but you have no callers at this time.
Look at that, a perfect record of no public comment in Commerce and Labor this entire session so far. Any comments from the members? All right, with that, we adjourn and look forward to seeing everyone Wednesday morning at 8 a.m.